Welcome to the Ratio Podcast. I'm Gideon, and today we are mapping the appellate minefield of the Philippine civil procedure, a landscape where one wrong step can cost you your entire case.
And I'm Chomar. We have synthesized the doctrines from over a dozen landmark cases to bring you this guide. Whether you're a seasoned practitioner or a student in the trenches, the lesson from the Supreme Court is clear. In the halls of justice, procedure isn't just a suggestion, it is a jurisdiction.
Let's start with the hard truth. You don't have a natural right to appeal.
Exactly. B.R. Sebastian versus CA and BCDA versus CIR set the foundation. Appeal is a mere statutory privilege.
What's the ratio there?
The court is teaching us that because it's a privilege, the state can set gates. The most important gates are time and fees. In BCDA, the court held that payment of docket fees is jurisdictional. So no pay, no play. In B.R. Sebastian, they ruled that a lawyer's internal office mess is not excusable neglect. The negligence of counsel binds the client.
But there's a famous safety net for the 15-day deadline, right?
The NAPES versus CA doctrine. It teaches that if you file a timely motion for reconsideration or MR and it's denied, you get a fresh 15-day period to appeal from the moment you receive that denial.
But wait, does NAPES rule apply everywhere?
No, and this is where lawyers get tripped up. In the case of CIR versus Standard Insurance, it reminds us that the Court of Tax Appeals has its own 30-day jurisdictional window, and you cannot use general procedural liberality to bypass the CTA's special laws. In the case of Pates versus Comelec, it teaches that the 5-day period to appeal Comelec resolutions is strict and non-extendable.
Usually, we go straight to appeal. But in family law, there's a detour.
This is a critical distinction. Under AM number 021111 SC or annulment and AM number 030404 SC or the custody or habeas corpus, you must file an MR or a motion for new trial as a precondition to an appeal.
What's the principle?
The court wants the trial judge to have the first opportunity to correct errors regarding a person's status or a child's welfare. If you skip the MR, your appeal is premature and will be thrown out.
We have a cluster for cases about picking the wrong lane.
Okay, so let's categorize them. Rule 41 or ordinary appeal, it is used when the regional trial court acts in its original jurisdiction. In the case of Municipality of Bacon versus Municipality of Sugpon, it teaches us that the boundary disputes between towns are original regional trial court cases. So you use Rule 41. And in the case of East-West Banking versus Cruz, it says that if your issue is purely legal or no evidence weighing, you go straight to the Supreme Court. If you use Rule 41 to the CA for a pure question of law, it shall be dismissed and not transferred. And lastly, on the case of Yatco versus Office of the Deputy Ombudsman, it teaches us that administrative ombudsman cases go to the Court of Appeals via Rule 43, but criminal findings only via Rule 65 certiorari to the Supreme Court.
If I miss my 15-day window, can I just file certiorari under Rule 65?
The court in Pahila Garrido versus Tortogo and Salednap versus De La Peña says a resounding no.
What is the teaching?
Certiorari is an extraordinary remedy for jurisdictional errors. It is not substitute for a lost appeal. Brual versus Contreras adds that you cannot file an appeal and a certiorari simultaneously because that's forum shopping.
Once a case is final and executory, is it over?
DBP versus COA says yes. Judgments are immutable. However, FGU Insurance versus RTC provides a narrow exception. If a supervening event after the judgment becomes final that makes its execution unjust or impossible, the court can modify the execution, though not the merits of the judgment.
Final takeaways, Cho.
First, check your mode. If you're in the wrong lane, the court won't help you change. Second, check your preconditions, especially in family law. Third, count your days. NAPES is your friend, but Standard Insurance is your warning.
That's the ratio. Procedure isn't a technicality. It's the foundation of law. See you next time.